Today I'm going to take an exam that I have never seen before. This is a real past bar exam question, and I will go through the steps I recommend you take and that I would go through if taking the bar exam today. By the way, shout out to Andrew for suggesting today's topic. Hello, my lawlings. This is Professor Beau Baez. The exam question I'm about to review was from the July 2012 multi-state essay exam. As a rule of thumb, you should spend 25% of the allotted time on an essay question in pre-writing, which means reading the question, taking notes, highlighting, and preparing a short outline on what you are about to write. Studies indicate that those who pre-write outperform those that read and immediately start writing. Students on this exam had 30 minutes to answer the question, which means I have about 8 minutes for pre-writing and 22 minutes for writing my essay. All right, here is my screen. Now what I'm going to do is, right now the torts exam is not showing it. You'll see it on the left screen. So I have not seen this exam. I have no idea what's going to be on there. I'm going to take this exam under timed exam conditions. That means closed book, closed note, and as I say in class, open mind. So I have a timer here. I'm going to hit the 30-minute mark. Let me just tell you a little bit about my process. I've mentioned this before, but this is the process that I highly recommend. I think you should all use. So the whole idea behind this exercise is to show you how somebody uses my techniques in taking an exam, an essay exam. So the middle screen, a little tiny one in the center, I'm going to use that for notes. So what I'll do is I will read the essay question. In fact, what I do is I start at the bottom, I read the call to question, I then go through the facts. Just because it's online, I'm probably not going to, normally I would take notes of some kind on the exam paper and separately on a separate page of paper, like I'm going to do here in the center. And then the exam itself, once I'm ready to actually begin writing, it's going to appear on the far right. So my technique is you want to spend on a 30-minute essay about 8 minutes pre-writing. And that's what I'm going to do. So I'm going to be reading, taking notes, law. Again, I have no idea what the rules are going into it. I don't know if this is going to be an intentional tort, negligence, strict liability, have no idea. Just like I would on an exam. I just wouldn't generally have that information. So this is an old bar exam question. It's only 8 years old at this point, but it'll give you a sense of how to do that. So I've got my timer. Let me go ahead and start. And then I have 30 minutes to really press on. So let me start. All right, exam has begun. Oh, went too far. Okay, so here's our torts question. So I'm going to start down here at the bottom looking for the call of the question, because that's going to then give me some context for what I'm going to follow. So at the time of the attack, Susan knew, and only slightly because they'd been in one class together the previous semester, Susan is seeking damages for the injuries she suffered as a result of Anne's attack and has sued the university, Jim, and Anne's psychiatrist. So immediately I know I've got 3 plaintiffs, right? So she's suing university, Jim, and psych. Whatever. I'm just going to PSYCH. There we go. So those are my 3 parties. So these are the 3 that I'm going to have to explain. So may Susan recover for physical injuries she suffered in Anne's attack from the university, Jim, and the psychiatrist. Okay, they're already there. Assuming that any party is found liable to Susan, may she also recover damages from that party for the PTSD. Okay, so I'm being asked about physical injury and emotional harm. All right, so as soon as I see emotional harm, I start thinking we've either got potentially an II. Well, I'm going to find out. It could be an independent IED claim, NIED, or if there's physical harm associated with the tort, then it becomes parasitic. So let's just see. Now I'm going to read the question. 2 minutes down. Susan, a student at university, lived in a university dorm. Access to Susan's dormitory was restricted to dormitory residents and guests who entered the dorm with a resident. Entry to the dorm was controlled by key cards. Dorm key cards opened all doors except for a rear entrance, used only for deliveries, and was secured with a deadbolt. On November 30th, in the 2 a.m., so I know that's early in the morning, late at night, depending on how you look at it, a university graduate entered the dorm through the rear entrance and was able to enter because the deadbolt lock had been broken during a delivery 4 days earlier. Anne's entry had not been repaired. Anne attacked Susan, who was studying alone in the dorm's library. All right, so we've got like a negligent security theory going on here. Jim, another resident of Susan's dorm, passed the library shortly after Anne had attacked Susan. The door was open and Jim saw Susan lying on the floor groaning. Jim told Susan, "I'll go for help right now." Jim then closed the library door and went to the university security office. However, the office was closed. Jim took no other steps to help Susan. All right, so with Jim, we're dealing really with the rescue doctrine. So I'm going to put down here, rescue doctrine. For the university, I know it's already kind of like a negligent security, negligence, right? But it's lack of security. All right. So anyway, Jim did nothing else. About half an hour after Jim closed the library door, Susan got up and walked to the university hospital where she received immediate treatment. One day after the attack, Susan began to experience mental and physical symptoms. Insomnia, anxiety, rapid breathing, okay, a whole bunch of things. All right, so those are physical manifestations. All right, good. Susan's doctor has concluded that these symptoms are due to post-traumatic stress. According to the doctor, Susan's PTSD was caused by trauma she suffered 1 month before Anne's attack, when Susan was robbed at gunpoint. In the doctor's opinion, although Susan had no symptoms of PTSD until after Anne's attack was triggered PTSD because Susan was suffering from it by the earlier robbery. The symptoms became so severe that Susan had to withdraw from school. She now sees a psychologist weekly. Since the attack, Susan has learned that Anne suffers from schizophrenia, a serious mental distress illness. From August through November, Anne had been receiving weekly outpatient psychiatric treatment from her psychiatrist. Her psychiatrist records show that on November 20th, Anne told her psychiatrist that she was going to make sure that former university classmates who were cheaters got what was coming to them for getting the good grades I should have received. Anne's psychiatrist did not report these threats to anyone because Anne had no history of violent behavior. Anne's psychiatrist also did not believe Anne would take any action based on these statements. All right, so the psychiatrist, we have their claim is a third-party claim, and it's a duty issue, right? The question is, does a psychiatrist have a duty to warn? And that goes to the California case. Okay, so right now, 24 minutes. I've got about 1 more minute to do some pre-writing. So I've got the 3 theories down: negligence according to the university, rescue doctrine for Jim, and the psychiatrist, the third-party claim duty, the Tarasoff case. That's what I'm thinking of. So this is a Tarasoff issue. All right. So I am ready to begin. So what I'm going to do is open up with a very quick topic sentence. There are 3 lawsuits by Susan, each predicated on 3 different theories of negligence. All right, so in this case, I don't see any intentional torts. It's all going to be negligence. Then I give negligence, 3 each 3 lawsuits. Okay. The suits are against the university for negligent security, Jim for failing to rescue, and tryst Susan, right? And I'm just going to call her from now on Susan, for failing to warn of the attack. All right, so I've kind of given negligence occurs when the following 5 elements are present: duty, breach of duty, actual cause, proximate cause, or legal cause if you prefer, and damages or harm if you prefer. And then my thought is the psychiatrist. Oh, that is so her psychiatrist. Do we have a name for the psychiatrist? I guess it's just psychiatrist. I don't have a name. Okay, so we're going to call it psychiatrist. So there we go. And just to make it easy for me, PSYC. PSYC. So if you're going to have any things short, just do that. PS Psych. I guess that's easier for me. Susan will likely prevail against university, but have a harder time against Jim and Psych. All right, there we go. All right. The first defendant is Jim, who is alleged to have negligently begun. First of all, Jim and and I always want to keep an eye on my eyes, so I've got 20 minutes left. All right. Let's keep moving. First is Jim, and the issue is whether he owed any duty to Susan, a stranger. Okay. Then the rule of law. Strangers generally owe no duty of care in negligence cases to those that they happen to meet, unless they commit a negligent act, something like that. All right. The law implicated by these facts is the rescue doctrine, which holds that there is no duty to rescue a stranger, but that when a stranger begins to rescue, they must do so reasonably. The question that must be decided is whether Jim's actions were reasonable. All right, 18 minutes. I gotta move fast here. Let's see here. What do I know? looked up here. I'm going to make this my issue statement here for the next week. The question is whether reasonable. Jim found Susan hurt and told her that he was going to get help for her. While he did go to the security office to get help for her, the office was closed. At that point, he did nothing else. The issue for Susan is determining whether Jim should have done anything else. Under the traditional rule, a rescuer is not liable if they do not place the victim in a worse position than when they were found. Here, Susan was arguably not made worse off by the rescue attempt. So Jim owed no duty to her for his failed rescue. All right, so I'm done with that. We got to move on because at this point I'm down to 16 minutes, 8 minutes for the last two. So the next one I'm going to deal with is psychiatrist. The second, and I'm kind of going from the what I think are easier claims to the harder one. The university I think is the hardest. The second defendant, psych. Can be sued for negligence in failing to warn Susan of Anne's dangerous behavior. Generally, a psychiatrist owes no duty of care to members of the public unless the patient members of the public for the conduct of their patients. However, courts have found that a duty is owed if a two-part test is met. One, the patient is planning to do something that results in death or serious bodily harm, and the psychiatrist reasonably believes that the patient is going to carry it out. Right. A related rule is that the victim can be readily victim is readily identifiable by the patient. All right, so now we're going to go into the facts here. So we have let's see. Okay, she never said, Susan, in this situation, Anne did not disclose who in this situation, Anne told, so you gotta psych, that she was going quote, going to make sure that cheaters were going to get what was coming to them. This statement is ambiguous in that it does not demonstrate that Anne is going to do anything that will result in death or serious bodily harm. Quick time check. Ooh, 10 minutes. Okay, I gotta move fast. Death or serious bodily harm. It does not identify Susan, and it and in any event, Psych did not believe Anne was going to act on her feelings. Psych should prevail against Anne. All right, next. The third defendant, University. Sorry. And by the way, minor typos are generally ignored on the exam. Can prevail will likely lose in a lawsuit for negligent security. The university owed Susan a duty to secure the dormitories as that is what a reasonably prudent person would do. It appears the university was aware of security problems given the access cards that were needed to enter the dorm. 4 days seems the locks to the rear entrance were broken, and the university failed to repair in a timely fashion. Okay, I've got 7 minutes left. Because of this, university breached their duty to Anne. The next elements involve causation, actual and proximate. Actual causation is measured by the but-for test. Here, but for the university not securing the dorm, and would not have been injured by Susan. Proximate cause is measured by the foreseeability test. It is foreseeable that someone might enter a dorm when the building is not locked. However, since Anne is a student, it might have been foreseeable that she could have entered through another means. Finally, there must be damages and suffered physical and emotional. Physical harm, this element is met. Wow. All right, I've got 4 minutes. The last question asked, assuming that any party may also recover for the PTSD. The final question is whether, okay, 4 minutes, whether Anne Susan, all right, whether Susan here, not securing the dorm. Sorry, I got the wrong parties here, don't I? It's Susan. Let me just fix that very quickly. Whether Susan would not have been injured by Anne. Ooh, I hate when that happens. Since And as a student, am I, okay, good, I got that right at the end. So here it's Susan. I caught the phone is whether Susan can recover for her emotional harm based on PTSD. This is an issue related to causation. 2 minutes, okay. Specifically, proximate cause. And whether the eggshell psyche rule applies. Though Susan was susceptible to a PTSD attack, it was not triggered until 2 minutes. It was not triggered until Anne attacked Susan. It is under this rule, one takes a plaintiff as one finds them, and the unforeseeable extent of injury is ignored. Because there is a causal link to her current emotional 30 seconds. Emotional harm, because there is a causal link to her. No time for correcting her current emotional harm. She will be able to recover for this harm. Normally, it's only 12 seconds left. So that is it. We are now officially done. I move on to the next essay. So it's not pretty, but it's done. Mention the main issues and just typed away. So that's basically a 30-minute bar exam essay. Hopefully this was helpful for you. And you just have to realize you have to keep your eye on the clock, and when it's time to move on, you move on. Wish I'd had more time, but I don't. That's the nature of a bar exam or any sort of timed exam. I hope you found this instructive, and if you have other video suggestions for me, please send them along. New videos every other Wednesday, so hit the subscribe and bell buttons so you can become a better student and a better lawyer.